No, it's okay. I'm not going to use it. Can't read those little notes at the bottom there anymore.
Okay, cool. Okay.
Good.
You got a
Perfect.
clicker?
I have a clicker.
There.
Perfect.
There.
There it goes. See, it'll see it. It's-
All right.
Yes,
Anything else?
okay, so we'll make sure I know how the clicker works.
The one that's, it's my clicker, so the one that's rubbed off. Is
Yeah.
the forward one.
Okay, that makes sense, except it's not working. There, I just need to be pointing it at something. Yeah, okay, there we go.
It's upside down.
So that's the reason.
Yeah.
I got it. I'm looking at the one that's on the couch.
Right, yeah, the one that's completely rubbed off.
Completely rubbed off. Got it. Okay. Okay. All right. Just let me know when we're ready to go.
We got plenty of time. Transition is around 4:20, sort of like.
Yep. So we'll be done by then. Yeah.
Perfect.
Yeah.
I
Absolutely.
usually ask a lot of questions.
Okay.
Mostly lining up after you ask for questions.
Yeah. Yes.
That's
I get
really-
it. Yeah, because that would be way too public.
Right.
Raise your hand, but
Totally.
if you can come up and ask the questions afterwards, it's
Totally.
do it that way. Okay.
Awesome.
All right. Perfect.
Yeah, that's it. You want an amplified microphone to save your voice?
That's probably.
Yeah. 1, 2. Yep. Yeah.
I've done this before. One, two.
I can hear it.
Okay,
You're
so
just not as close to, or here.
I'll put them on my local color. Right-handed, it's easier to do it this way. I'm trying too softly.
Yeah.
Hello.
Yeah, it seems like it's really close because we can.
All right, so I'll go at it this way. Hello. Hello? Okay.
I don't know how I can.
No, I actually, I was successful. I straight this as but it's as they say, it's got three degrees. So I just this subjectivity. I guess I understand that. That was hard. So you wanted to be too today?
Yeah, no, I got you. Great.
Yeah.
You'll tell me
Yeah. What is
literally this. Yes. Sitting on the ground.
All right, good afternoon, everyone. Thanks for coming. Good afternoon. Can you hear?
Yeah.
Yeah, okay, good. Thanks. So I'm going to start off with telling you a little bit about why I think privacy, why engineers should care about privacy. And I'm going to do a little bit of my background, and that'll help you understand why, and then I'll go into more detail as we go along here. So for most of my career, I was a lawyer at a bank. And I started at a bank in Chicago that went through a bunch of mergers, which ultimately ended up being JP Morgan Chase. So I won't bore you with all of the different mergers that we went through. But for one of the mergers that happened before the privacy law for banks, Graham-Leach-Bliley, went into effect, one of the things that the senior executives wanted to do was put into place, and this happens after you do a merger, is you've got to merge the different systems of the two companies that merge. And one of the senior executives for the consumer lines of businesses wanted to merge all of the retail or consumer banking systems so that all of the businesses that were engaged in consumer banking could see the customers of all of the other lines of businesses that were in consumer banking. And the idea was that if you could see all of the customers in the other lines of business, then you could cross-sell to the other customers, and that would be good to grow the business of the new bank, the new combined bank. There's nothing illegal about that. There's nothing wrong with it. And then shortly thereafter, Graham-Leach-Bliley was passed, and shortly after that, a California privacy law was passed that put limitations on being able to share your customer information. So after we went through this huge merger, this huge effort to make it possible to share all of this information, we had to undo it. And the business people were very upset because they'd spent a lot of money doing this. And of course, they couldn't have anticipated the law. And it was just one of those things that happens. New laws get passed, and you have to spend money to get in compliance with new laws. And then down the road, we've had some recent experiences where new laws have been passed and businesses have had to spend a lot of money getting in compliance with them. So, for example, just recently in Europe, a new privacy law was passed called the GDPR. And we're going to talk about that today, what some of the components of that are. And businesses, large businesses, have spent millions of dollars getting in compliance with that because it's very complicated and it has a lot of limitations on what you can do. And now in the US, California has passed new privacy law, and the same businesses that have had to get in compliance with the GDPR now have to get in compliance with California. And there's some similarities, but they're not identical. And they've had to spend a lot of money getting in compliance with California. Well, the reason why it's important to understand all of this is if you build your products in a way that doesn't anticipate all of this, then you've got to undo it. So the reason why I told you about the first example was you had to undo something that you already did. But if you have an understanding of what privacy laws is, and I don't want to make any of you privacy experts today, the only thing I want to do is make you sensitive to what some of the issues are about privacy law, because all I want you to do is have a little bell go off in your head when you're building a product for whatever company you go to work for. And I'm going to give you a current example today of a project that I'm working on where we had this exact issue. I'm now, and I'll talk about my background for a minute just to get to this example. So from the bank, when I left the bank, I went to work for a startup at NYU, and I was there for a couple of years. And now I'm a consultant, and I'm also the co-founder of a SaaS website. And in connection with that website, me and my co-founder, we're not in the same location all the time. And we have an engineer who's not in the same location that each engineering team, that's not in the same location that either one of the two co-founders are in. And so we're building an addition to the website right now. And it's very clear what needs to be done about, at least we thought we made it very clear to the engineering team what needed to be built. And unfortunately, the engineering team, and this is a privacy website, and the engineering team made some assumptions about what needed to be built as they went along and built it. And we got to the point where it's not totally built, but it's 75% built. And we said, well, what about this? This doesn't work, we need to change that. And the engineer made some assumptions and said, no, we're too far along, it'll cost a lot of money to change it. And we said, well, but the law doesn't like it. This is a way to implement the GDPR, help small and medium-sized businesses to implement the GDPR. And we said, well, but that's not going to work for the way the law works. And he said, well, I made these assumptions. And so this is an example where the little bell needed to go off, and you needed to come and ask us. And we've been meeting daily, but we had given instructions, we had given explanations about why it needed to be done, but assumptions were made by the engineer. And now it's, unless we're going to rebuild this whole thing, and which costs money, we have to live with it the way it is. Well, that's great if you're a big company and you've got lots of money, you can sort of undo it. But if you're a small firm like mine, no, we're going to have to live with it for a while. So it's really important, and this engineer doesn't have any privacy background, so this person didn't think to ask these questions, and we didn't know that these assumptions were being made. So it's really important for you to, you as engineers, to understand when questions need to be asked. So nobody wants you to be a privacy expert, but it's really good to have just a little bit of understanding about what the privacy law is. So if you have an understanding about what it is, you can think to yourself, oh, there might be some privacy implications here. Maybe I should go ask. So you think that in a small business where it's a very small team and you know what's going on, it would be easy to have those kinds of conversations. I just gave you an example of where it wasn't that there weren't conversations going on. We have conversations daily, but assumptions were made. And that was the problem, and didn't even think to mention the fact that those assumptions were made. And you can see how as companies get bigger and bigger, it's easier for those kinds of miscommunications to happen. So I'm going to walk through a little bit. I'm going to give you a hypothetical that we're going to walk through today and talk about some privacy issues. We're not going to cover the gamut of privacy law. We're not going to come anywhere near. I have no intentions of doing it. Don't even say to me, oh, but you didn't talk about so-and-so. Happy to talk about why I didn't talk about so-and-so. But just, I just picked out some of the current hot topics today, and we'll using them as examples of things to make you aware of what some of the hot issues are today. But this is something that I think would be helpful no matter what you're doing in your career as an engineer. If you're working with anything that has to do with consumers, individuals, people, live, breathing individuals, no matter where you're working, no matter where you are in the world, there's probably some kind of privacy interest that you need to, if you want to be really good at what you're doing, I think it's really important for you to have some just general understanding about what privacy law involves. So let's talk about what our hypothetical is today. And if you've got questions along the way, I'm happy to take them. There's going to be time for questions at the end, so feel free to either ask as I go along or at the end, there'll be time. Sure.
Before I forget, what's your name, ma'am?
Oh, sorry, Lynn Goldstein.
What?
Lynn Goldstein.
Thank you.
Okay. So our hypothetical today is we're going to talk about a travel business that operates a website and it offers tour packages on all 7 continents. Our customer is in California, and it purchases a tour packages from World Travel, the global World Travel. And the tour packages involves travel to destinations in Illinois, in the US, and in France, in the EU. So we're going to be focusing on privacy laws in Illinois and in the EU today. Travel America conducts tours in all 50 states. Travel America is a subsidiary of World Travel. And Travel Europe conducts tours in all 27 EU countries. So we've got 2 different subs, one in the US and one in the EU. To provide these services, World Travel collects personal data, personal information of the customer, and in this case, our customer is a woman, and her family, and shares this personal data with Travel America and Travel Europe. And both of these subs share some of this data with service providers. And the service providers share this to help them provide these services. To earn additional revenue, World Travel sells the personal data that it collects, okay? You're the senior engineer for World Travel, responsible for building the company's products so that they comply with the world's privacy laws. And it's also important to remember that the customer is traveling with her family and needs family-friendly accommodations. Biometric data is also going to be collected for admission to theme parks in Illinois and France, similar to like what Disney World does. And there's also going to be activities for preteens needed because she's got minor children. So, you know, keep that in mind as part of the facts that we're going to be dealing with, okay? So the data that's going to be collected by World Travel to be shared with the 2 entities are obviously name, address, the biometric data, billing information, names and ages of the minors, names and of other adult family members, and obviously arrival times, dates and times. To make these necessary arrangements, World Travel is going to share the customer's personal data with Travel America, as I mentioned, and Travel Europe. And Travel America and Travel Europe are going to share this information with the service providers. And this personal data is going to be used to make these travel arrangements and handle last-minute travel changes and address local issues. The service providers are also going to help with billing and direct marketing issues. But another fact that we need to keep in mind here is some of World Travel's customers have complained that after signing up for tours with World Travel in the US and in the EU, they started seeing charges that aren't theirs on their credit cards. So we've got some data breaches, it sounds like, that might be going on. Okay. So now we're going to start getting into the laws that might apply here based upon these facts. So don't worry about keeping track of all those facts. I just wanted to give you a flavor of what kinds of facts. I'll tease out the facts as we go through the laws, and you'll see why they're relevant. But giving you an idea of why certain laws apply based upon these facts. So the first law we're going to take a look at, we're going to go through the U.S. privacy, some of the applicable U.S. privacy laws. Trust me, we're not doing all of them today, but some of the applicable U.S. privacy laws would be, first of all, there's a federal law that governs what you can do with children, minor children's information. So if you're a website owner, which World Travel is, it's unlawful to collect or disclose personally identifiable information from a child under 13 without obtaining prior parental consent. So since World Travel needs to collect this information in order to make the kinds of arrangements that the customer wants to be made here, they must collect this information from the parent, can't collect it from the child, and you can't disclose this information to third parties without parental consent. So you're not going to be able to give this information to the theme parks or the hotel or anybody else without parental consent. And you're going to have to figure out a way to collect that information. Since this is a website business, it's not, a walk-in travel agency where you go in and you provide this information in person. You're going to have to figure out a way, as you're building these products for World Travel, you as the engineer, you're going to have to figure out a way to collect all of this information securely, and you're going to have to figure out a way to collect it in a way that shows that you have the consent from the parent, so that you collected this information from somebody other than the child. The way this issue usually crops up is games for children. Children have their own phones, they have their own iPads, and they want to sign up for these games. And that's why I mentioned that there's going to be activities for preteens such as VCRs, iPads, Xboxes that are going to be provided in the hotels for these kids. And where this issue usually crops up is the kids sign up for the games. How are you going to prove that you've got parental consent for the games that the kids who are under 13 are going to sign up for? And so you've got to figure out how to do that as well. Now, in this case, it's just a travel agency, but if you were one of the hotels that you were, had these people staying at, you have to figure out a way, if you're providing the Xboxes, the VCRs, the iPads, figure out a way to collect that consent and know that you were getting it from a parent. So these are the kinds of issues when you're building these services. You as the engineer are building these products for your employer. You're going to have to take these kinds of issues into account. Okay, let's look at another privacy law. This one is in Illinois, and it's the Illinois BIOMETRIC Information Privacy Act. And it says that a private entity can't collect, capture, purchase, receive any age person's biometric information unless it first informs the individual in writing that that information is being collected, that it informs them of the purpose for which it's being collected and the length of time that it's going to be stored and used. And you have to receive a written release executed by the person from whom you're collecting this information. So how are you going to collect this written release on your website? Because you're the one who's collecting this information for the theme parks for whom this biometric information is going to be provided. Because you're providing a one-stop service here. That's what you advertise on your website. So first of all, World Travel must notify the customer on the website this information is being collected and stored. And the purpose you're collecting and storing it is for being able to access the theme parks. And you need to obtain a release. And I'm telling you that one way you can obtain this release is through some kind of DocuSign or something like that. So it's not just enough to provide the information, but you actually have to figure out a way on your website to actually get that written release signed. So this is one kind of technology that you're going to have to actually help your employer build into their website. A little challenging here maybe. If you want to be able to collect this kind of information and offer that kind of one-stop shopping, that's the kind of requirements that you're going to have to build into your website. All right, so we've addressed some of the issues that have been raised by our facts here because we have minors, we have biometric information. So let's see what else we've got to deal with here. Well, California has this new law coming out at the very beginning of next year. It goes into effect in 2020. And it may, you guys are going to know about it now, so you might want to follow it as it comes into effect because Microsoft just announced that it's going to apply the California Consumer Privacy Act US-wide. So even though it's only written to apply to Californians, Microsoft has announced that it's going to apply it throughout the U.S. And it contains a number of consumer rights related to California's personal information, but they're going to apply it to everybody in the United States. So you might want to follow up and see what happens to this. This just came out yesterday that Microsoft made this announcement. And some of the things, this is a very complicated law. There's a lot of different facets to it, but I picked out some of the highlights of it here. One of the things is, some of the things that it gives you is that it gives you the right to know what personal information a business collects about you, the sources from which the information is collected, and whether the business sells that personal information and why the business collects that information. The really controversial part about this is whether the business sells the information. If the business sells the information, and remember I mentioned that World Travel is selling the information because they want to collect additional revenue. If they sell the information, they have to give a link on their website in order for individuals to be able to opt out of the sale of their personal information. So something for everybody, all of us to watch out for as Microsoft applies this worldwide. But with respect to world travel, the other thing is that the California Consumer Privacy Act provides the right to request deletion of personal information a business collects about them, and as I mentioned, gives the right to opt out if is sold. So what must world travel do here with respect to its privacy, with respect to its website? Well, first of all, it must provide a privacy notice on its website that informs customers of the categories of personal information that it collects and the purposes for which the personal information is to be used. And it must place a do not sell my personal information or do not sell info link on its website homepage or on its mobile app landing page. When consumers click on this link, they must be directed to a notice that describes the right to opt out, how they can opt out, any proof required when a consumer uses an authorized agent to opt out, and a link or URL to the company's privacy policy. That's a lot of mechanics behind the scenes that have to happen, and you have to have the mechanisms in place to collect all these opt-outs and be able to honor them when they happen. You have to collect them, and then you have to keep track of them so that when you sell the information, you're not selling that person's information who has opted out. And then you have to, another thing that World Travel is going to have to be able to do is accommodate requests that are submitted to delete information through a toll-free number and from a website form accessible through its website or mobile app. So there's a lot in here, and as I mentioned, this will apply worldwide for at least one company, which has now raised the bar for lots of other companies in the United States. All right, so I mentioned also in our hypothetical that we think there's some data breaches going on. California has a data breach statute. It's the first state in the country to have a data breach statute. It's the one that we look at. Other states have more, have a data breach statute that could be slightly more rigorous than this one, but because it's the first, it's the one that everybody looks at to just see what a data breach statute in the US looks like. There is no federal data breach law in the US. It's 48 out of 50 states have passed a data breach statute. So what does it mean? It says that if there's an unauthorized acquisition of personal information, you must disclose it. The company must disclose it to, in this case, residents of California. And if there's more than 500, the acquisition of the information of more than 500 people, you must also disclose it to the California Attorney General. How do you know if it's been an unauthorized acquisition? Well, one of the ways to be sure that it's not an unauthorized acquisition is if you encrypt the information. So what everybody, hopefully everybody, but I just read up an example yesterday where there was a loss of an unencrypted laptop. But most companies went through an enormous effort to encrypt their personal data over several years. And so that's the first thing that World Travel should make sure is that all of its personal data, both at rest and in transit, is encrypted. Because if it's encrypted, if it's lost, if it's misplaced, if somebody tries to access it, it can't be a data breach if it's encrypted because of the way the California law is written, and a number of other statutes are written the same way. So this is the examples that we're going to talk about in terms of Illinois law or US law, but we're also going to look at EU law. Question.
Would this cover if there's, say, an employee who has authorization to access the information and then they use it maliciously later?
So if you've accessed it, then it's unencrypted. So if the statute would cover it, and if you're authorized to use it, but you use it in an unauthorized manner, it is a data breach. That's right. Yeah. So that's why it talks about an unauthorized acquisition. Yeah. So, okay. So keep this in mind. We're going to look and now we're going to turn to the EU because remember our customer went to the EU and in particular went to France, but it doesn't matter. The EU has a regulation which covers, it's like a federal law in the US. It covers everybody who's a member of the EU. So the law is the same no matter what country you're in the EU, except for some minor differences which don't apply here. So we're going to look at the same 4 subjects and what the law is in the EU. They're not going to be identical. And the problem is that what do you do if you're a world-wide business when the laws aren't identical? And we just learned about what Microsoft decided to do in the US when California privacy law was different than the privacy law in the rest, was different than the rest of the privacy laws in the other 49 states. They decided to apply it US-wide. So, but when you've got differences between different countries and you've got laws on the same subjects, and it's not so easy to do that. So we're going to, when we get done looking at the EU, then we're going to look at what you do with the differences, what it means when you have differences between the different countries. And how do you deal with that as a worldwide company? Because those are the other kinds of issues that engineers need to help their companies think through. What are the possible solutions that you can do based upon the technology possibilities? So let's take a look at the EU. So the first thing, minors, that was the first thing that we looked at in the US. In the EU, it's unlawful to, the term they use is information society services, but for us, the internet, it's unlawful to provide the internet to a child below the age of 16. Okay, here's our first difference. There it's 16, here we're talking about in the US it's 13. So, all right, already we've got a problem. How do we make the distinctions between 13 and 16? So it's unlawful to offer the internet to a child below the age of 16. And the processing of the data of a child below the age of 16 is lawful only and only to the extent the consent is given by either a parent or somebody like a guardian. Since World Travel uses its website to collect information about children under the age of 16, it must collect the information from parent, and it can't even share the information without parental consent. So that's another difference between what it was in the U.S. So we'll come back and talk about these differences between what CAPA or the child privacy law in the U.S. at the federal level is and what the EU privacy law is in a minute. All right, let's look at biometrics in the EU. The GDPR provides that the processing of biometric data for the purpose of uniquely identifying an individual is prohibited. This doesn't matter what age you are, unless the individual has given explicit consent to the processing of their personal data for one or more specific purposes. If you only give the consent for one purpose, then that's it. That's the only reason you can use it, and it has to be explicit consent. So World Travel must obtain on its website the customers, in this case plural, because everybody's going to the theme park. We got to get the consent of all of them. And remember, because we've got children, we need the parents to provide the consent for the children, one of the parents, to provide explicit consent to the collection and use of biometric data so they can go to the theme parks. All right, and then the GDPR has a whole bunch of individual rights that are provided to for people. And we're only going to talk about a couple of them because we only talked about a couple under California. And we could spend probably a whole hour talking about the individual rights that the EU provides. But just to make it sort of parallel here, we're going to talk about similar rights that are provided under the EU. So first of all, you have to provide, the individual has the right to know for what purposes personal data about them are processed. And processing in the EU means anything you can do with data. Collect it, use it, receive it, store it, anything you can think of to use it. So we're going to use this term processing very broadly. And you also have the right to know what categories of recipients your data is being shared with. And where applicable, if that data is being transferred outside the EU. And if it is being transferred, how are you making sure that EU law is governing that when that data is being transferred outside the EU? You also have the right to obtain confirmation whether or not an organization has collected data about you, and if they have, you have the right to get access to it. You have a right to obtain correction of inaccurate data. You have the right to get personal data erased in certain circumstances, and you have the right to receive personal data that you have provided to the company, transmitted to another company. This is called the right to have your data ported, right of portability. And you have the right to demand the company provide your data, the data that you have provided to that company, to have that company provided to another company. So what does World Travel have to do here? Well, it has to provide a notice on its website that informs customers of the purposes for which the personal data are processed, the categories of the recipients of the personal data, and where applicable, if the data is being sent outside the EU, and what measures it takes to protect it, to make sure that it's covered by EU law. It also has to inventory the personal data it collects and uses, so it can respond to access requests to correct the data, and to erase the data. So that could be an enormous engineering effort on the part of the company to figure out where all that data is collected and in order to be able to respond to all of these requests. And then remember, I talked about the right of portability. So if you have that right of portability, the company has to provide the information to the customer in a structured, commonly used, and machine readable format. So that's another thing that you're going to have to be able to help your employer be able to do. And remember, we had a data breach. So the data breach law is very different in the EU. It means the breach of security leading to accidental, unlawful destruction, loss, alteration, unauthorized disclosure, access of personal data transmitted, stored, or otherwise processed. there's nothing in here about limiting it to unencrypted data. So it's much broader, and you must notify the supervisory authority, the regulator, within 72 hours. And if the breach is likely to result in high risk to the rights and freedoms of individuals, you have to notify the individuals as well. So you're going to have to figure out what kind of security measures you're going to put into place to protect from a data breach, because this law is much broader. So then let's talk about, so as I pointed out as we went along, we have a lot of differences between these laws, even though they cover on the same topics. As I mentioned before, in the US, the age of minority is 13, in the EU it's 16. For minors, it regulates collection and disclosure, but for minors in the EU, it regulates all processing. So how are you going to reconcile this? You run a global website. How are you going to do this? Are you going to are you going to go to the higher standard and apply, like Microsoft applied California to all of the US? Are you going to apply the GDPR to everywhere in the world? I mean, these are you going to have different websites for different parts of the world? I mean, these are solutions that you're going to have to help your the company that you work for try to figure out solutions to this. For the biometrics, the US, it was you had to provide notification and get a release. In the EU, it's prohibited unless you get consent. So there are two very different approaches that you have to take in terms of getting that. So if you want to collect biometrics on your website, you're going to have to provide very different solutions. Again, how are you going to reconcile those differences with respect to individual rights? The contents of the notices are different, and I'm sure a lot of you were receiving emails when the GDPR went into effect last spring and getting a lot of EU-specific privacy notices. That's why, because this stuff was very different. The rights that you have under them are very different. You can see some of them that I pointed out here. In California, it's deletion, and much broader in the EU. And in California, you've got this do not sell link, very different about what you have in portability. And data breaches, as I mentioned, unencrypted personal information, whereas in the EU, it's accidental or unlawful destruction, loss, or alteration. So these are examples of where where the law has changed, and you have to adjust to make these changes because the law has changed. But for the example that I gave for my little company, where the assumptions that were made, or you built the product because you didn't know what to do, it's really very helpful to be able to build the product taking into account the law that's currently in existence, so you don't have to rebuild it, keeping in mind what these privacy requirements are. And in fact, there's a provision in the GDPR that requires that you take privacy by design into account. So they actually want you to build your products taking into account what the privacy law is. And if you don't do that, it's not an excuse to say, well, we didn't build it in a privacy sensitive way, and so that's why this incident happened. You need to take privacy into account, and in fact, it's part of the law, and it's not going to be a response to say the product wasn't built in such a way that the privacy issues could be taken into account. So it's really important for you to be able to understand what these, at a very high level, just as I mentioned at the beginning, for a little bell to go off in your head and to say, you know, I think there just might be a privacy issue here. Before we get too far down the track, maybe I should go talk to somebody about this. And if you have any idea what privacy law is about, then the little bell should go off and you should go talk to somebody before you get too far down and it's too late to rebuild the product. So that's the message I wanted to deliver today, and I'm happy to answer any questions. We've got a good 10 or 15 minutes. Sure.
Will Nevada is following California faster one as well next year?
So California is going into effect in January 1st, 2020, and the state is given 6 months for there to be a grace period. But the statute actually goes into effect January 1st.
What about Nevada?
Which one?
Nevada?
I'm sorry, I'm not understanding. Oh, Nevada, the Nevada privacy law, good question. It's in effect already. It has a more limited scope. Nevada only applies to browsers. So, so that's why I didn't mention it. It's much more limited in its scope than California, but Nevada's in effect already. New York doesn't have a new law yet. It was trying to pass one, but it doesn't have one in effect yet. So, sorry.
For the US, why is it age 13 rather than 18 considered to be that all those laws apply to you?
Yeah, I don't know. You know, COP has been in effect for a good 10 or 15 years, and I just don't know why they chose 13. Yeah. Good question, though. Yeah.